Hello and welcome. I'm Amritan Rai and you're watching Law of the Land on Sabha TV. Today we bring to you the issues around anti-dumping. We will also discuss the Supreme Court order on anti-dumping. To discuss the issue, I have with me Mr. Abhijit Das, Head and Professor, Center for WTO Studies, Indian Institute of Foreign Trade, IIFT, and Mr. A.K. Gupta, Partner, TPM Solicitors and Consultants. Now for the headlines. The Supreme Court directs Anti-Dumping Authority to redo method of calculating non-injurious price. Directorate General of Anti-Dumping and Allied Duties is the nodal investigation agency on anti-dumping. And 55% of all existing anti-dumping investigations are against China. The Supreme Court, in one of its judgment, has ordered the Directorate General of Anti-Dumping and Allied Duties, DGAD, to redo the calculating method of non-injurious price for imposing dumping duty. Non-injurious price is the benchmark price calculated by the DGAD, and any imported product selling at a lesser price causing injury to domestic market can be accused of dumping activity.
While delivering the judgment, the Supreme Court said that the anti-dumping law is extremely important for countries' industrial progress and there should be proper transparency and fairness in its implementation.
The Supreme Court's decision was given in the context of the Act because there were no rules with regard to NIP at that point of time. So their approach, the decision, everything is in the context of the Act. Whereas the changes have been brought in the rules. So I don't think that it would be very appropriate to dilute the decision of the Supreme Court by changing the rules. But in practice, yes, today, what has been proposed in the landmark decision of Reliance is not being followed. To answer the question squarely.
The Supreme Court passed the order in the matter of Reliance Industries versus Directorate General of Anti-Dumping and Allied Duties, DGAD. The judgment was delivered by Justice Ashok Bhan and Justice Markandeya Kadzu. According to the judgment of the Apex Court, the Directorate General of Anti-Dumping and Allied Duties, DGAD, is required to carry out the determination of injury and computation of non-injurious price NIP for the domestic industry as a whole, and not in respect to any particular company. The court directed that both the normal value and non-injurious price should be calculated for exporting country and importing country. And once that is done, the assessment of dumping has to be established, and then the dumping duty can be imposed on all exports of those goods from that country. The court also held that Directorate General of Anti-Dumping and Allied Duties, DGAD, determination of non-injurious price was misguided, and it should be done on the basis of actual production during the period of investigation and not an assumed level of capacity utilization.
You cannot keep the administrative process as a secret, and that is a view that this Honorable Court has reiterated, that what the designated authority does cannot be kept confidential. And I believe that is very good for the practice of anti-dumping or any other administrative law in the country, that what the authority does needs to be disclosed to the party who is providing the information for sure, and in an index basis to the party who is not providing the information.
Dumping occurs when the goods are exported by a country to another country at a price lower than its normal value. This unfair trade practice can distort and affect international trade. Anti-dumping duty is a measure by the government to correct the situation arising out of the dumping of goods. By imposing anti-dumping duty, the government seeks to re-establish fair trade. Apart from NIP issue, Reliance judgment talks about another important aspect, that DA should maintain a balance between confidentiality and transparency in the anti-dumping cases. With camera person Raj, Aruna Thakur, Rajya Sabha TV.
The case related to the import of an assembled chemical used for the manufacture of textiles. The authority had imposed duty on the chemical originating only from Spain, and no duty was imposed on exports from other countries, for which the appeal was made to the Apex Court. My question to you, Mr. Das, straight away. SC judgment, what's the problem? Why can't the authority, the designated authority, the DGAD, actually practice what the court has directed? Where is the problem? They, on non-injurious price, they seem to be sticking to their way of calculation, whereas the Supreme Court has clearly said that you assess the actual production price at the margin and certain other aspects and then calculate the price. Why?
Firstly, for an outsider who is not directly involved in the investigations, it's next to impossible to understand how the NIP is calculated. Prior to 2011, at least in the public domain, there was no guidelines, no rules which would have helped any outsider to understand how the NIP was calculated. Now some guidelines have been put into place as part of the anti-dumping rules, and these guidelines give us some idea of how the NIP is calculated. But having said that, even if one reads the findings of the designated authority, my view is that we would just not be able to ascertain whether the Supreme Court judgment has been strictly adhered to. Only the representatives of the parties to the anti-dumping investigation get what is called a disclosure statement, which is not publicly available. And it is in the disclosure statement that the concerned parties get to know the basis of calculations, how the calculations were done.
Okay.
But having said that, let me also mention two aspects. The first aspect is that the Indian anti-dumping law essentially flows from the overarching WTO's anti-dumping agreement. WTO's anti-dumping agreement does not mandate calculation of a non-injurious price. That's the first important thing to be borne in mind. But having said that, India follows what is called the lesser duty rule, whereby it tries to seek a balance between the interests of the importers as well as the interests of the injured domestic industry. So as part of implementing the lesser duty rule, India calculates the non-injurious price.
I'll get in, Mr. Gupta. Mr. Gupta, on the NIP, do you think there is a tendency by the DGAD to go beyond what its brief is? That is, to protect the domestic industry, which is actually, it is not a protectionist measure according to the WTO. It is just supposed to be fair trade practice. But when you go to to any country, whether it be India, US or any other country, they have used this one line and interpreted it in a way that it ends up becoming a protectionist measure for the domestic industry.
As Abhijit said, WTO provides for what we call as a lesser duty law, which is not mandatory and only desirable. What I call is India is practicing a loose duty law. Essentially, there are two concepts behind what they do under so-called non-injurious price, which was a practice prior to the rules which have been framed now. One is that they consider that the cost of production or actual cost of production of the domestic industry is higher during the relevant period for certain other factors. The industry is consuming inputs or resources more than what is probably required in that particular period. Industry did not produce to the extent they could have produced. And as a result of these two factors, their actual cost of production is higher. Second concept which they consider is that once dumping is addressed, the industry would be in a position to increase their production. And if they increase their production, their cost of production would be lower. And if the production cost will be lower, why they should be protected at a higher cost, which is not in the consumer interest. This is the primary concept
But it
behind
is
the
assumed
NIP
on
law.
the producer.
That is the problem. That's
producing.
based on assumption.
Yes,
that
of the
in the
producer.
event of imposition of duty,
Yeah.
in the event of domestic industry achieving a higher level of production, their cost of production would be lower, may or may not be. And second factor, the cost of production, the investigation period might be higher for factors other than so-called inefficient utilization of resources. So I would probably put
You
this
would like
way,
to add to that,
it's a least duty law.
Mr. Das?
It certainly is a mechanism to balance, as I said earlier, conflicting interests. Interests of the domestic industry, which is getting injured on account of dumping, as well as the interests of the downstream users of the so-called dumped products. So it is supposed to be a lesser duty rule, and
That's how it is. The second point that I would like to take up is, see, essentially, if there is a product which is available at a cheaper rate in India, whether it comes from X, Y, Z, and if our industry is not being able to match that efficiency level to get us that produce at that rate, then why should the consumers of that country suffer just on the name of protectionist measures?
let's have 2 or 3 things clear over here. First is it's not the low-priced imports per se which is the subject matter of anti-dumping. There have to be 3 conditions which have to be satisfied before an anti-dumping duty can be imposed.
Dumping,
Injury and causality.
Yes.
And dumping involves a comparison of price between the price of the exported product in the exporting market as well as the price in the country which is importing it. If the export price is lower than the price at which the exporter sold it in his own home market, then that is dumping. But if that dumping causes injury in the importing country, then that is what is condemned by the WTO agreement and the GATT agreement. It is not low-priced imports per se.
that's perfectly all right. You're completely on what the logic is. But what is actually happening, Mr. Gupta? Is that what is happening, or it's completely different?
No, another point which I like to point out is that it is wrongly being perceived that this law is a protection law. It's a level playing field which is being granted to the domestic industry. And let's consider this way, in the name of consumer, we are trying to say that a duty lower than dumping should be imposed, which is already put in place under the law. We are now going beyond that level. And as I would repeatedly say, the most developed economy in the world in terms of USA considered it necessary not to apply a lesser duty law, and they go to the full extent of dumping margin. A country like Europe applies the lesser duty law but goes by actual cost of production. India made a proposal to WTO to bring in an NIP law, similar to NIP law, into the WTO agreement, which was, I think Vijit will comment on that, was probably not accepted by most of the WTO member countries. So let us take this way. There are only limited number of countries who are practicing dumping law. India is one of them, but there are a lot of countries who are actually on the receiving side. Still, the NIP law proposed by India did not find a significant favor in WTO member countries. So why so?
I get it. It's time for us to head into a break. When we come back, we will talk about the powers of the Anti-Dumping Authority, the DGAD. Welcome back. Nearly 55% of all anti-dumping investigations in the country is against China. The anti-dumping duty is an instrument to ensure fair trade competition and is permitted by the World Trade Organization, WTO. The Directorate General of Anti-Dumping, DGAD, is a nodal agency, investigating agency under the Commerce Ministry for the investigation into anti-dumping cases.
The 2 qualifications to attract anti-dumping investigation leading to imposition of anti-dumping duty are sufficient evidence to prove that there is dumping and that there is injury caused to the domestic industry. The Directorate General of Anti-Dumping, DGAD, is at the forefront of these investigations. It has initiated 275 anti-dumping investigations between 1992 to 2012, which included almost 42 countries. Out of these, 150 anti-dumping cases have been initiated against China alone.
At any point in time, as you may be aware, there are about 50 investigations ongoing with the authority. A typical person at the seat of authority would not be more than for 1.5 years to 3 years, which means that any time when an authority changes, there would be anywhere between 25-30 investigations, where probably investigations would be at advanced stage. I would not be surprised if tomorrow we find a situation where suddenly authority has changed and there is no time left to complete the investigations within the statutory time period of 18 months. That's one area where I feel we have not introduced the law in the way it is really understood and implemented globally.
Let's look at the powers of Director General of Anti-Dumping and Allied Duties. The authority is headed by Additional Secretary Rank Officer in the Ministry of Commerce. The authority is assisted by a Joint Secretary and Director, 4 investigating officers and 4 costing officers. The authority can conduct anti-dumping investigation and make recommendation to the government for imposition of provisional and final anti-dumping duty. The authority initiates investigation on receipt of a petition or can take up investigation on its own. The authority is expected to submit its final finding to the government within 1 year from the date of initiation of the investigation. The authority acts independently and its order can be challenged. The Department of Revenue, Ministry of Finance may, on the basis of the recommendation of the authority, impose duty on the offender.
There needs to be standardization of initiation. What is acceptable as data in one case sometimes is not acceptable as data in the other case, and I'm saying that again this is because of the difficulty there is in obtaining reliable official data, but sometimes we feel that the standard for initiation is at best patchy, and that is something that needs to be looked at.
The anti-dumping agreement and the GATT agreement lay down principles to be followed by the member countries for imposition of anti-dumping measures. Accordingly, Indian laws were amended in 1995 to bring them in line with the provisions of the agreement. In India, China is leading in the anti-dumping cases, and because of this reason, India got a big amount of trade deficit in the current year. With camera person Raj, Aruna Thakur, Rajya Sabha TV.
Section 9 of the Customs Tariff Act and the Custom Tariff Rules of 1995 form the legal basis for anti-dumping investigations and for the levy of anti-dumping duties. Mr. Gupta, straight away to you. First question, continuity, the point that you made. How big an issue is that? Continuity of the head of DGAD.
We have not faced, as I said, any case so far where the investigation was lapsing because of the DA changing. The reason is that, as the decision says, the DGAD was not conducting a hearing with change in authority. The Supreme Court judgment has come only recently, and after that there has been only one change of authority where they had to repeat hearings in all those cases. There would be a change in authority in due course. We need to see whether there is any situation arising therefrom. We do have a situation now where an investigation has gone beyond 18 months, which is, I would say, probably is global rare case so far. But that is not because of change of authority, that is because of court intervention in an anti-dumping investigation, where a stay was granted to an anti-dumping proceedings, because of which the considerable time was lost, investigation could not be completed, and the Supreme Court granted an additional time to complete the investigation beyond 18 months period.
So basically, I understand, these are the problems which are existing there. Now these problems are have started to occur. On the continuity basis, you have said that there's been no problem as yet, but apprehend a problem in future, right?
That's right.
Okay, now on the second point, specialized authority for a specialized legislation or a legal framework like this. Do you think getting IS officers or bureaucrats to do this activity, or the rank of additional secretary, is that the way things should go, or do we need to bring in a completely specialized agency with specialized tools?
We already have a fairly specialized agency undertaking anti-dumping investigations. It is headed by an IAS officer who is expected to have the broader perspective of public interest. The investigating authorities are drawn from a variety of experts, variety of services, cost and account service. You would have some people from the trade service, some people from audit and account service. So these officers do embody considerable expertise required to undertake an anti-dumping investigation. I think the problem is not really of expertise in the officers, but the very limited number of officers which are available to undertake these investigations. Compared to the number of cases which our investigating officers handle, even a country like Turkey, they would have, I would say, almost 8 to 10 times the number of officers handling fewer cases. I'm not even talking of the United States. So I think that is the problem which needs to be tackled.
Understaffed. They are badly
understaffed.
Grossly understaffed.
And the consequence is that many of the obligations, particularly relating to transparency, which are mandated by WTO's anti-dumping agreement, many of the transparency obligations, questions could be raised. And that is where my real concern is. We already had a very big dispute against India raised by the European Union in the year 2007, where 27 of our anti-dumping cases were dragged before a WTO dispute. That dispute did not reach a panel stage. It was amicably resolved before that. But one of the core issues in that dispute related to transparency in our findings. We may have followed the obligations, but how we adhere to those obligations was perhaps not adequately reflected in our findings. And one of the reasons I would guess why that did not happen was that the DGAD is grossly understaffed.
On the question of reliable data on part of the companies and the way the authority uses that data to establish certain benchmarks. Is that a problem? Do we have enough reliable data?
I will probably disagree with Suhail on that point, not that issue, that we lack reliable data. We, in fact, have quite good recourse to reliable data. In terms of, if I compare with the investigating authorities of other countries, we do get almost comparable kind of information. The problem which we face in India is insufficient participation from foreign producers. There may be some situations where information is available but is not being readily transmitted or made available to the investigating authorities. Customs information in detail is available, which is probably not being that exhaustively used at present. And I think there is already work underway on that. And after the 27 cases which Abhijit mentioned, I would say there's a sea change in the situation. And if we talk about current situation, we are talking about a difference of between an undergraduate and a postgraduate. That is where probably we are in terms of our present findings. But yes, as he said, the real problem is grossly understaffed investigating officials. I was talking to one of the officers who said he received a 21st case last week. One officer handling 21st case. If I tell a government foreign party, they'll be laughing at us.
Time for us to enter into a break. When we come back, we will show you an interview with an expert, partner Luthra & Luthra, Moshmi Joshi. Welcome back. My colleague Aruna Thakur spoke to Moshmi Joshi, partner Luthra & Luthra, and tried to get her point of view.
The Reliance judgment of the Supreme Court is one of the landmark judgments which forced the government to introduce law for the NIP. So, what is the practice does the DA presently is working?
I think the DA is also of the opinion, particularly when it comes to capacity utilization and parameters such as that the domestic industry should get what is due to them, which is the best use of their capacity, right? Which is why the practice which, the judgment sort of came down on is still not being followed, and they follow the were practicing even previously. So it doesn't seem to have made that much of a difference how the DA is arriving at NIP.
Still, anti-dumping law is new to India. do you find any lacuna in the whole anti-dumping law?
The lack is really in the capacity of the directorate as such and the procedures. Very simple issues. For instance, even though the DGAD notifies the cases, on the website, it is very difficult to find which is the latest case which is notified. What is the latest development on the case? There is a notification. It comes 4-5 days late, 5-6 days late. So information is not up to date. It is not immediate as it should be, right? There are rules which are set particularly for Chinese exporters which are different from exporters from other countries. For instance, a big problem that we have is that petitions are initiated on the basis of the domestic industry calculating the normal value based on constructed price. It is a practice which has just become endemic to Indian anti-dumping law. It's not actually provided under the WTO rules.
Most of the cases of anti-dumping of India is against China. So don't you think it will lead to trade gap between India and China?
You know, it's very interesting and it's ironic that despite India having initiated the most number of cases against China, China is our largest trading partner. China used to be, I think, the second or the third, and America used to be our largest trading partner. But I think the latest data that we have, China is our largest trading partner. So what I'm trying to say is that our actions don't actually affect the amount of exports that are coming in and the need for our industry to rely on China. The problem is our user industry needs those inputs that are coming from China for whatever reason, be it capital goods, be it certain types of chemicals, be it certain types of technologies. So I think what our government has to address is why, despite the protection which is given and a sort of help which is given to the domestic industry, why is it that the user industry is still relying on Chinese to provide them with certain inputs and raw materials?
Any exporter whose margin of dumping is less than 2% of the export price is excluded from the ambit of anti-dumping duties, even if the existence of dumping, injury, as well as the causal link is established. My point, the point that you wanted to make on the WTO issue and the data bit, quickly, sir.
At the WTO, India had made a proposal on lesser duty rule. This was made in 2005 March. Contrary to what Mr. Gupta mentioned, this proposal gathered considerable momentum, and my understanding is just US is opposing, standing in the way of this becoming accepted. On the issue of data, my real concern is in respect of dumping of agricultural products. We do not have a systematic mechanism in place to gather data on injury parameters if, God forbid, there is dumping of agricultural commodity in India tomorrow. And our agriculture sector might not be able to take advantage of the anti-dumping duty.
Absolutely. On the point of transparency and the other allied issues.
What I want to say over there is that in order to increase transparency, there is a need to give increased support to the directorate. The issue is not really in terms of bringing transparency. The issue is in terms of being able to really disclose what is required by the parties. As Mosmi had mentioned, we are talking about online information system. Even 3 to 4 days is being considered as a long period. What is required over there is probably overnight situations for which what is required is adequate manpower. As I told you, 21 cases being handled by one officer. I think 4 days is a very good time limit they are adhering to. So if you want overnight, you need to probably increase the staff strength to probably 10 to 20 times of what it is at present.
Thank you, sir, for joining us on this discussion. It's time for us to end the show. You can email your suggestions and comments to law.rstv@gmail.com. You can also watch our shows on the YouTube. We'll be back with a new issue and a new episode. Keep watching Rajya Sabha TV.